Everyone, and welcome to the Cuyahoga County Court of Common Pleas Black History Month event. And we are calling this a special conversation with our own Justice Melody Stewart. I am Judge Cassandra Collier-Williams, and I currently sit on this bench of the Court of Common Pleas, and I am very, very happy to be here and very happy that all of you have decided to log on today. My job is simple. I'm just going to introduce the Honorable Judge Solomon Oliver, who in turn will then introduce Justice Stewart. Now, I had a whole sheet of things to say about Judge Oliver, and I was told not to say them. So he said, I'm not the focus here. But I do want to say that while I was attending Cleveland Marshall College of Law, I had the honor of having Judge Oliver as my professor in trial advocacy. And the only thing I can remember about that class was that we were so serious. All of the students, we really got into our trial advocacy so much that we would be arguing and we'd be fighting. And Judge Oliver would say, why are you guys so serious about this? He really was trying to calm us down. And we know now that his demeanor is a very, very calm demeanor. So we tried to learn from that. So it was a great experience. So without any further ado, Judge Oliver is on the State's District Court for the Northern District of Ohio. He is in senior status at this time. He has been there since 1994, and he was appointed by President Clinton. Without any further ado, Judge Oliver, if you will unmute yourself, it's on you now. Thank you.
Thank you, Judge Kaya Williams. And that's right. I didn't want you to say too much, but you did share a few things, and I appreciate that. You're very kind. Let me first commend the Common Pleas Court for having this program and the other programs you're having during Black History Month. We're having a program here at our court, U.S. District Court, at the end of February also, and every year we have a program. And I just remember when I was growing up, that's from Alabama, and that was a lot of years ago. We celebrated Black History Month. In fact, it wasn't a month then, it was a week. But I remember during that week when we celebrated Blacks like Hank Aaron and Willie Mays, both who were from Alabama, and Joe Lewis and Jesse Owens and Mary McLeod Bethune and so forth. That was an important time to us because while we were being put down throughout the larger society and there was racism everywhere, we were really kind of holding ourselves up. Our teachers were letting us know that we could achieve, that we could do anything. And so that was a very important time for me during that period of time when I was growing up in Alabama. And so I always look forward to Black History Month. It's my honor and privilege today to introduce your guest speaker or your guest speaker, Justice Melody Stewart. Now, I've known her a long time, a lot of years, I would say, probably more than either of us would care to recount. But I'm going to recount them. Some would say that Justice Stewart needs no introduction. But Justice Stewart, you're getting an introduction today, I assure you. Let me just say that Justice Stewart comes to her current position as Justice of Ohio Supreme Court with really more preparation than one could ever imagine. She really is prepared for that position. And we're so proud of her in terms of how she's going about being a justice on that court, how she's representing all of us, how she is making sure that that everybody is respected. And so that we're so proud of. Now, in terms of education, some of you know her background. She started out at the University of Cincinnati Conservatory of Music. And then she, after graduating from there, came to Cleveland Marshall College of Law, Cleveland State University. And after graduating from there, and a few years having passed, she kept going to school and kept going to school. She's never had enough of school. And so she received her PhD at the Mandel School of Case Western Reserve University. It's a lot of education, Justice Stewart, but I don't think it's gone to waste. I first came to know Justice Stewart. I'm going to try to call her Justice Stewart throughout, but if I slip up and I call her Melody, I think she'll forgive me, and I hope you will too, because I've really known her a long time. I first came to know of her when she applied for law school at Cleveland Marshall. I was on the faculty at that time, and I either chaired the admissions committee or I was on it. I can't recall, but I certainly was on it. And I remember when her application came through, and all this music stuff. And normally we're looking at English and history and social sciences and maybe some science, and we try to make something of the transcript. And we looked at hers. All we could make of it was that she was very good at what she was doing. We knew nothing about music theory and all the other courses and how to evaluate those, but we knew she was good at what she was doing. So she was. We rated her very highly, and she received a very special scholarship there when she was at Cleveland Marshall. And she was a student of mine, and she was very, very good. But the one thing I would say about her is that no matter how good she was, you could always tell it wasn't enough. She was always working hard to do better, to gain really more background, more credentials, more understanding. That's, I think, been a lifelong thing with her, and I've noticed that throughout her career. Now, she's done a lot of things, and that's why I talk about her preparation, because she was administrator at 2 law schools, both at Cleveland Marshall and both at Cleveland State, at Case Western Reserve University. And when we were at Cleveland Marshall, we were there together because this was after she graduated. She came back. She was assistant dean, and I was associate dean there. And so we had a chance to work together. And then she took her skills across town to Case Western Reserve University and was director of student affairs, of student services over there for a period of time. But she was, beyond being an administrator, at certain points, she was also a professor. She taught, and so she had both the administration background, also she had the background of being a professor. And then beyond that, beyond that, as some of you may know, she also practiced law. She was assistant law director, the city of Cleveland, and assistant law director in East Cleveland. So when she came to the court, that is the 8th District Court of Appeals, she came with that strong background. A person who had practiced law, a person who had taught law, a person who had been an administrator at law schools. She brought all that. And she served with distinction on the 8th District Court of Appeals for a number of years. And she had the opportunity and served with distinction as the presiding judge on that court. And so the thing I couldn't figure out was someone who had such a significant position, who was doing well in that position and being reelected time after time, why she would branch out all over Ohio and spend all of her time in all the counties of Ohio and work hard to try to become a member of the Ohio Supreme Court. I understand why she would want to do it, but trying to envision how it could happen. I guess that's what I mean. How could it happen that she would actually get elected, or anyone would get elected having to go through all of that? But that's the kind of determination she has. That's the kind of determination she's shown. And that's what I meant when I said she's always striving to do good, but to do better. And that's what I've admired about her throughout the time that I've known her over these so many years. And so let me just say very quickly in concluding that if I know she's a justice, but if Justice Stewart was a judge on the Common Pleas Court or anywhere else, I want her to be my judge. And that's whether I did it or not. I want her to be my judge. And if I had tough legal issues to be decided, I want her to be my justice. And that's regardless of whether she came down in my favor or not. And that's what I respect about her, that she takes her oath seriously, that she administers justice without respect to persons. And that's the oath she takes. And I could say it another way, that she administers justice without fear of favor. And so when I think about the role of a judge, I think back to the 78th Federalist. And that was written by Alexander Hamilton. And there he described judges as faithful guardians of the Constitution. As faithful guardians of the Constitution. And I'm just so pleased, I'm just so proud that Justice Stewart is a faithful guardian of the US Constitution, of the Ohio Constitution, and the laws of these United States and the state of Ohio. And so I give you my friend and all of our Justice Melody Stewart.
Thank you for that introduction. Judge Oliver didn't tell you how many years, but it's been 37 since law school, and I find that hard to believe. So thanks all of you for participating. When Judge Cassandra Collier-Williams asked me to do this, I said, "You're kidding, right? Because didn't I do it last year?" And she said, "No, if you recall correctly, you were the introducer last year." So last year I was Judge Oliver introducing Judge Blackman. So, I rather, in the time that we have, answer things or talk about things that you want to talk about, and I don't know whether, there'll be time afterwards to ask questions or whether you put them in the chat and they'll be monitored, but please feel free as we go on. One of the things I'd just like to take this opportunity to say to you, I imagine all of you, if not the majority of you, are lawyers, and we're in an interesting time with the law, and there's been pundits talking about possible constitutional crises, and both at the federal level and the state level with various things going on. So I just want to say that I think now more than any time that I can remember in my time as a lawyer, as a judge, is a time for us to kind of gird our loins, and for us to be out front in so many ways. And I don't necessarily mean loud and boisterous, but at least in that helping to dispel inaccurate things that are being said either in the media or amongst people, and helping to impart our knowledge about the things that are going on, probably now more than ever, particularly to the lay population, people who aren't as familiar with the laws. It was indeed the highest honor for Judge Oliver saying if he needed to judge or be in front of a judge, he would want it to be me. And I try to strive and do that every day. For those of you who are trial court judges who see, particularly the common pleas court level, the man in humanity against man on a daily basis, and trying to mete out, keep respect for your court, respect for the defendants who are in front of you, respect for victims of their alleged crimes. And it's a balancing that you have to do every day, and then try to mete out justice in the wake of all that is going on. And I always, from the very minute I started practicing law, and I can hope to continue to do this until I'm no longer working in the profession, is that I've always tried to put myself on the other side, in the place of the other person, be that a criminal defendant, be it opposing counsel, be it a victim of circumstance, be it a plaintiff who has been injured, being a defendant who is trying to minimize, their risk, and then, all that balancing, an equitable outcome or a just outcome. And with regard to our criminal justice system, we've got to do something different. And I really mean this more so to those of you on the bench. Police and law enforcement officials are not going to stop arresting, and they shouldn't. Prosecutors are not going to stop prosecuting people, and they shouldn't. And likewise, judges are going to keep adjudicating and presiding over criminal cases and imposing some sort of sentence that he or she feels is just based on the circumstances. But what we've got to realize is we've got to recognize our part in the bigger system. So therefore, as we continue to incarcerate people and have longer incarcerations and recycling defendants to our system, the vast majority of those people are going to get out. And when they get out, science and statistics have shown it has such a negative impact on certain communities. We've got to figure out a way to recognize our part in this system and make it better. Yes, you have to continue doing what we do as judges, and we can't change that. We aren't policymakers, but our voices need to be at the table for times when policy decisions are made. So for those of you who aren't already on committees and commissions that deal with these certain issues, please, I implore you to get on those. And we have to think about too, when we're incarcerating people, that's good in that we are protecting society from those offenders, particularly those repeat offenders, but they're still going to come back out. And when they come back out with the collateral consequences of being incarcerated, aren't we just going to see them again? So aren't we continue to recycle people or put these people in our communities with no jobs and no gainful employment, no opportunity to get those employment, and being shielded away from education and training and housing, and aren't we just putting them in a community where the next offender who has not yet committed the offense or who has not yet been caught or incarcerated, how are we protecting against those offenders? So I like to come up a way, and I wish I could wave my magic wand and had an answer, but for us to do things on the front end too, as opposed to the back end. I know criminal justice reform is being talked about all across the country with regard to policing and incarceration and sentencing, but we've got to figure out a way to do something to affect the front end of that process too. And so, as my time on the I'm more than a little bit halfway through my time on the Supreme Court. It has been a whirlwind of 3.5 years, and every time I think I'm hitting a stride, something will come up and throw a monkey wrench in it, some surprise or expedited something that happens in the Supreme Court. Please know that I feel blessed and privileged and honored to be there, serving in the capacity at the highest court in our state. And it is never a dull moment there. For those of you who haven't been there, please, next time you're in Columbus, take the opportunity to stop by. If I'm there in my office, I'll even take you to lunch if I can pull away for a moment. It's the court is about to change. The Chief Justice is leaving at the end of the year due to the age bar for judges. And so we will have a new Chief Justice at the beginning of next year. And whoever she is, and I say she because obviously the two candidates are female, whoever is the next Chief Justice, we need to hold her accountable for everything she needs, just as I think we have done with Chief Justice O'Connor. And so as these things happen, as changes happen in the courts, we know what the coronavirus and the pandemic did, particularly those administrative judges and all courts having to figure out how we move forward. I think some things are great. I was amazed to find how many courts in our states lack technology initiatives, and we sent out money, I think probably close to $3 million, trying to move some courts kicking and screaming into the 21st century with technology, but continue to improve, use this opportunity to figure out how to best operate your courts and your court systems. And I'll just kind of say on a final note to maybe leave some time for questions too, we are, I feel at a crossroads in whether we take this launch pad and make the way we practice law, the way we administer law better for our society as a whole, or whether we just kind of plateau and then begin to fall backwards. So I encourage all of you who are on this session to be part of that launch pad and to figure out how it is that we get better. We become better jurists, and we become better lawyers, and we become better citizens, and try to leave something better off for the generation behind us. So I'll stop talking right now on that and see if there are any questions anybody has that I can answer.
Alita, do you have any questions yet?
one of the questions that we want to ask is to tell us about your path to the Supreme Court. Obviously, we've heard a little bit about your biography, but sort of tell us about your path. And so was this something you had always sought? Was it something that emerged? How did you get to this place?
That is a question that I'm often asked, and it really is kind of just by fate and faith. I spent 3 years of going to law school at Cleveland Marshall, really trying to figure out if I really wanted to be a lawyer. So I never really thought about the work I would do. And I've never really equated my education and training and background with the work I would do, as evidenced by the fact that I have a bachelor's degree in music theory. So if I had thought about employment or career, I would have said, what will you do with a bachelor's degree in music theory? And then I wouldn't have gone and gotten a bachelor's degree in music theory because I can't come up with an answer. But that's the only thing I wanted to study. And so I didn't think when I was in law school, and even when I came out of law school and started practicing, I didn't think about the bench. And I was, there were judges, of course, on the bench that time, Judge Una Keenan, who I see on this session, and Judge Ron Adrien, and Judge Sarah Harper, and the judges who were on the municipal court. We were probably exposed in Cuyahoga County to more judges of color probably than anywhere else in the state. But that just was never in my lexicon or in my path. And so I never thought about becoming a judge until I did, until someone mentioned if I ever thought about running for judge. And with all due respect to my trial court judges, I said, absolutely not. I could not imagine seeing that man in humanity against man every day, seeing lawyers who aren't prepared or who are inept. I'd want to call clients over to the side and say, hey, you might want to get another lawyer. And I know I can't do that. So I just thought, no. And then the person said to me, no, not the trial court judge, a court of appeals, because I was in law academe, and that seemed like the natural path from law academe to the appellate court, because you research and write. And so, I started pursuing that. I'm not a political animal. I don't feel I'm politically connected in any way. So I had to just I had to find out, what do you do? And so I had to find out what it took to run for judge. And in Cuyahoga County, and as most of you know, I was not successful. My first 2 attempts to get on the Court of Appeals. It was my third time, which was going to be my last time, because if it didn't happen then I figured it wasn't meant to be. So the third time, was a charm, and it got to the appellate court. And of course, it's difficult getting to the appellate court, not having been a judge before, because naturally a lot of trial court judges look to go to the appellate court, at some level. And they had the benefit of already having their name on the ballot. And a lot of voters, unfortunately, don't know the difference between, a municipal court judge and a common pleas court judge and an appellate court judge. It's just all a judicial office. And so it is hard getting to the appellate court from not having served at the trial court. And I was encouraged to try to get a trial court seat, but that just is not what I wanted to do. It's different work. And so the Supreme Court was, that's probably a whole discussion for another day, but after being approached to run for the Supreme Court on several occasions, I just felt that 2018 was the right time to do it. And when I decided to do it, I decided to do it only if I could get the right people in my campaign who knew what they were doing, because running statewide is not for the weak of heart, and it's more than just a notion. And if I could not get those people, because I knew nothing about running statewide, then I wouldn't do it. It was just a large amount of time and energy and effort I wasn't willing to invest if we didn't have the chance, give ourselves the best opportunity to win that election. And so my approach was just twofold. One, I had to pick what would be my overriding purpose of running for the Ohio Supreme Court. And that might sound strange, because you might think, well, isn't the overriding purpose to win? Now, winning would be a result of the election, and I only had, that much control of that. So my overriding purpose of running was to, one, try to get to all the other 87 counties and get to as many of them as I could, and to talk about the importance of the court and give us civic lessons on our judicial system, on what the different courts do. I would often give an analogy of, judges are kind of like doctors, if you will. If you think of your professor at some colleges, you call him or her doctor, and the person who takes care of your teeth, you call doctor, and the person who takes care of your cat or your dog is called doctor, and the person you take your kid for to childcare, the pediatrician, is called a doctor. But you wouldn't let any of those people perform open heart surgery on you, now would you? But they're all doctors. And so I try to explain the differences between the judges at the federal court level and the trial court level, common pleas, and the differences in the court. And I was amazed at how many people were just grateful for that civic lesson and that explanation of the courts and why it was important for them to vote on the court for judges. So therefore, regardless of what the results were on the election for the campaign, it will have been well served in my crisscrossing the state, meeting people who I'd never would get a chance to meet before, and to give that civic lesson. And then the second most overarching part too of my campaign was there was not going to be any negative campaigning at all. And I told everyone to a person in my campaign, if I have to spend a minute talking negatively about my opponent at all, then I'm wasting time not saying why I feel I'm the better candidate. And so I promised everyone in my campaign, I would do my part to be the best candidate possible. And if that wasn't, good enough come election time, then that's not what I was supposed to do. And so, and I treat the job of the Supreme Court like I did on the Court of Appeals, like I did as assistant law director, like I did as an assistant dean and a law professor. And to that, in that regard, a newspaper, I delivered the newspaper for the Plain Dealer as a kid. I babysat. I work, it's the way you work that I think is more important than so much so your title.
Thank you. I like that last comment, especially, no matter what role we're in. I have a couple of other, couple more questions for you. This one is, what do you think of the role of the judiciary during an era where democracy, public confidence, and human relations may be eroding?
The role of the judiciary is to try to maintain and hopefully improve that confidence in the system. I mean, I think people have to feel that when they are before a judge in any arena, that they are being seen, they are being heard, and the circumstances of why they're there is being fairly adjudicated. And that has to be the case. And I really do want to emphasize seen and heard. We bring all of our backgrounds to our jobs. Judges are no exception. And we have to recognize that we are judging the case and the issues, and we should not pass judgment on the individuals before us, regardless of what they've done and regardless of how heinous a crime might be. I'm of the belief, and call me a hopeful optimist, if you will, but I'm of the belief that the overwhelming majority of people want to be major positive contributors to our society. And unfortunately, so many people who come before us in the criminal justice system have not had the opportunity to do that and to be so. And so it has ended up that those people commit crimes or don't have any value for life or for anybody's safety, and sometimes for our property. But I believe if given the opportunity, those people too would want to be positive contributors to our society. I think we all do want to help our fellow brothers and our fellow sisters. And I think there's a sense of community that everybody has. Sometimes that community manifests itself in negative ways, and in organized crime and in gang violence. But if you think about it, that's what that is too. It's a sense of community and helping out each other. Unfortunately, with some criminal enterprise, and that isn't a good thing. But why can't we give those people the opportunity to do better? I think that's the overriding drive in our safety forces, those men and women who want to be members of law enforcement and of the fire department and of EMS and paramedics. That's why those people do that. They don't make a lot of money, but they want to do their part, to help others. And so I think we need to feel the same way as judges. I know we aren't social workers, but in whatever way we can fashion what we do to help either reintegrate somebody back into society who has committed a crime. And why is it that when we punish offenders who have committed a crime, we want them to, our system is such that we want to punish them for the rest of their lives. The collateral consequences that we put on the back of that, we need to figure out a way, I think, to better reintegrate, particularly even our juvenile offenders back in society, if we want to be a better society, or else we're just giving lip service to the idea.
Pretty powerful final thought there. Yeah, what is that answer? Here's another one. What do you think about the new law that allows for designation of party in the Supreme Court and Court of Appeals races? Do you think it will matter positively or negatively?
I don't know. Will it matter? Yes, it will matter. And the effects of that mattering will remain to be seen. I will just be completely frank and honest with everyone in this group. I think the law is strictly political, because it's the timing of it makes me feel that way, quite frankly. Not only the timing of it, but the selected races that are on. So the motivation behind it allegedly was voters want to know what party their judicial candidates belong to. Not like it's a secret. I mean, we do have to circulate petitions. The media will always say, who's running as a Democrat and who's running as a Republican. So it's really no secret. But the alleged reason behind this is, people want to know on their ballots whether who they're voting for is a Democrat or a Republican. And so the problem with that is, I think it says to people in the branch of government that I think is the most respected, that it allows people not to find out about the candidates' backgrounds and credentials. It I think politicizes a branch of government that really should not have the political moniker. I know some people says, well, it tells them about their philosophical backgrounds and their differences. Well, not really. It really doesn't. So I think it's contrived and it's manufactured. And then last but not least, if indeed you really feel, General Assembly, that people want to know who their judicial candidates are by way of their political affiliation, then why isn't the designation on all judicial races, not just the Supreme Court and the Court of Appeals? So is it coincidental that an all one-party Supreme Court now is as diverse as it could be by way of political party? Is it coincidental that now suddenly we want to know who the R's and D's are, now that we have a more politically diverse Supreme Court? And now that we have more diverse courts of appeals across.
What happened here?
I think Justice muted herself. Okay, she's back on. Okay.
Am I back?
Yeah.
Am I back on? I didn't do that. Somebody else did it somehow. I didn't, at least I didn't try to. So I'm sorry about that. So I just say, I don't know where I cut off, but just to say that it just seems coincidental in timing that now that the Supreme Court is the most politically diverse as it's been in decades. And likewise, our courts of appeals across the state are more diverse. My understanding, actually, to show about the politics of it is, my understanding is that they were going to put it on all the judicial races, at least from the Common Pleas Court up above, but that some Republican judges in some of the larger counties screamed bloody murder and said, no, we'll never get elected if you put R's and D's on in Cuyahoga and Lucas and Franklin and Hamilton. And so those members of the General Assembly backed off of that and then just said, we'll just do it. Well, people only want to know who their Supreme Court candidates and Court of Appeals candidates are politically, even though the trial court judges are the ones that they see every day in the courtroom. People only want to know who your Supreme Court and Court of Appeals candidates are for voting. So that's just part of the politics that I despise so much when it comes about electing judges.
Thank you. So the next question asks, what was your biggest surprise when you joined the Supreme Court?
Biggest surprise.
Yeah.
Well, coming from the appellate court and you know, the 8th district being comprised of the largest appellate court in the state, I remember, don't tell my colleagues this, but I remember when we would say on the Court of Appeals, you know, what do those Supreme Court judges do? You know, they only hear about, you know, I don't even know, well, 500 cases a year, or no, what am I saying? We only hear about 100 cases a year, and it takes so long to get the opinions out, and you know, what do they do? And then I got to the court and I said, oh my God. And I told all my Court of Appeals colleagues, don't ever question what the Supreme Court does now. So because, you know, it's, you know, as you all know, you get to go to the Court of Appeals as a matter of right. All you have to do as an appellant to the Court of Appeals is file your appeal, get it in time, file the appeal, make your assignments of error. You can appeal, you know, traffic ticket, termination of parental rights, whatever. You have to ask us to get into the Supreme Court with you know, some exceptions, death penalty cases, public utility cases. So therefore, we have to look at the cases that want to get in the Supreme Court first. And we evaluate 40 to 50 of those cases every other week to see whether you get in on jurisdictional appeals. And then, then those are the cases we hear for oral arguments. But remembering, we're the court of original jurisdiction for writs, mandamus and procedendo and habeas corpus, and the appellate court for when the courts of appeals get original actions and they get appealed. And then all the disciplinary stuff across the state, all the judges and lawyer discipline, you know, across the state. And then the bar admission stuff and how we're going to now do the bar exam now that we're in a pandemic and can't take, you know, in-person bar exam things. And, you know, the Supreme Court has about 260 employees in different divisions, and the educational process of lawyers, you know, and the difference, I tell my former Court of Appeals colleagues, you know, when we were on the Supreme Court, on the Court of Appeals, we divided up the work amongst the 12 of us in 3 judge panels. And you had an actual vacation when you left on the Court of Appeals. Not so on the Supreme Court. My very first vacation I tried to take, I'm reading a brief on my cell phone on the beach in Mexico because we had expedited election cases. So it's a lot of work and it's a lot of reading. That was my biggest surprise.
Overwhelming volume.
Overwhelming volume.
Yeah.
Because the 7 of us have to decide on everything, as opposed to parsing out to 3 judge panels or individual judges deciding on it. All 7 of us have to weigh in. And oftentimes, as you quite imagine, it's not unanimous. And then we've had opinions with 5 different opinions written on it. You know, a lead opinion, a couple of concurring, a couple dissenting. And sometimes that's what takes the time to get things out, because 7 people have to weigh in, and often it's not unanimous.
Wow, that's interesting. Thank you for that. Let's move on to maybe a little more into some of those decisions. Can you share or talk a little bit about some of the more impactful decisions that you've made or been part of on the Supreme Court?
I always say the next one.
Ah.
Because it really, if you think about it, they're all pretty impactful. I mean, we're the direct appellate court for death penalty cases. Those are impactful. We have to resolve conflicts among appellate districts. That's impactful, to make sure that, you know, the 8th district and the 1st district don't decide an issue 2 different ways, and that there's uniformity of decisions in our court. And then, of course, we only, on a jurisdictional appeal, we only take cases that are of great general interest or of public, great general interest or public interest, or that has some constitutional issue. And so we are not an error correcting court. Sometimes we will look at a jurisdictional appeal where the appellant will say, wow, the Court of Appeals really messed up on this one and got it wrong. And we'll look at that jurisdictional and say, wow, they sure did. They missed the boat on that one. But we won't take it in to correct the error, because we're not an error correcting court. And we're not a court like the Court of Appeals We don't decide cases in controversy. We decide larger issues. Of course, they impact the people who are in those cases, but we're taking it not for them. We're taking it for its greater ramifications. And for the lawyers on this call, I encourage you to take that to heart. When you're trying to get into the Supreme Court, and the beauty of the diversity of the Supreme Court now, I think, is because when cases don't get in, then they're effectively decided by allowing the decision to stand. And so with a more diverse court, and I don't necessarily just mean, ethnic diversity, because, I'm it, but I mean diversity of perspectives and diversity on background and diversity on approaches, because there are oftentimes, I can think of one case where there was a 6-1 decision not to bring a case in. And that one justice who lobbied to get that case in and pointed out its importance ended up getting a 4-3 vote to get it in. The case came in, we heard it, it ended up being a 7-0 unanimous decision to reverse. And that case would have never seen the light of day had that justice not argued the importance and saw the different perspectives. And so, getting the case in, getting a case in itself is a huge decision, because oftentimes that doesn't make it. And so so for lawyers who are trying to get into court, if you're going to argue what a major injustice the decision was at the Court of Appeals to your client, you're likely not going to get in. You have to always frame your issues in a broader context, how this will impact criminal justice across the state, or how it will impact personal injury, or how it will impact contract making. When you file a jurisdictional appeal, and we don't have the record when you're filing an appeal. So when you do your memorandum in support of jurisdiction, that's got to really say things in the way that could get in the appellate court. And if you focus on your client and your client only, you will likely not get in.
Oh, very good. I have a couple more. What do you think the perception is when we get a lot of 5-4 decisions from the US Supreme Court?
Assuming that they're broken down amongst party affiliations, which wouldn't be the case now. What is the makeup in the US Supreme Court? I think it's 6-3 now by political affiliation. I think that people think, naturally, you think it comes along party lines. I mean, in our recent decisions in the Ohio Supreme Court, in the redistricting cases, that was it. We have 4 Republicans on the court and 3 Democrats on the court, and it came down 4-3 with one of the Republicans voting with the Democrats. But it's natural to think political affiliation. I'm often disappointed by that thought process. I begin to see how some maybe political thought processes play into it. If you're a conservative thinker, then you see everything this way and you don't go outside the boundaries. I think if you're a more liberal thinker, you think about how things, I think you're more likely to rubber stamp things if you have a limited conservative view. If your perspective is a little broader, then you see things slightly more different. But I don't think we have made lots of decisions in the Supreme Court that have not come along party lines, and we have been cross-affiliated with each other on numerous occasions. So I think it's easy to think of things that way, but that really is not the case most of the time.
All right, questions are rolling in here. This is great. So how often are you required to be in Columbus? Do you mostly still do stuff in the Cleveland area, or are you there, or how do you do your work?
Well, like most of you, we were working from home during the pandemic. Usually when I'm doing a Zoom session, I do like this when I'm in Columbus, or like that when I'm in Cleveland, or this is a great one for Cleveland, by the way. This one I use in the evening because it's a beautiful picture of the flag. I'm fortunate that I had a law clerk who was also a amateur photographer, and so I got a lot of great. I use this one when I want to be somewhere special. And then I use this by the seasons. So I am in Cleveland most of the time, but we're back to in-hearing persons. We started back in September. So we went back to in-person hearing September. For a year and a half. We did Zoom. We did Zoom hearings. So when you see us online and you see that background, we're doing our Zoom hearings. It's our faux bench in the back. But I am either home working or I'm crisscrossing the state, as we often do for various things. January is always a busy month for us because we're swearing in people all over the state. I started off swearing in the mayor of Lima at the end of December, and then did some local elected officials. So we're called upon across the state to swear in elected officials. We're usually asked sometimes to do commencement speeches or to be keynote speakers for different places. And so that was probably the best blessing for me in 2020 when the pandemic hit, because all the going to different events came down to virtual events. Things are gearing back up now. We even dispense with off-site court, which we would do twice a year. We dispensed with that completely in 2020, and we only did one in 2021. So we're doing those again, where the court moves to 2 different counties. I think we are scheduled. We did Summit County at the end of last year, and I think we're scheduled for Fayette County in a couple months. And I forgot who we're doing at the end of the year. I think maybe Williams County. So it's just so much more than reading and writing and reviewing cases and jurisdictional. So most of the time I am not in Columbus. Most of the time I am in Cleveland or somewhere else in the state.
Very good. Could you just discuss briefly the current goals of the Ohio Black Judges Association and how others can support those goals?
I am not the best person on this video to discuss that. Judge Collier Williams, Judge Rose, I think a lot, let me say this, I think people are going to, particularly in the judiciary, maybe look to the Ohio Black Judges Association to not just be a group of Black judges. And it's not even all Black judges. I mean, there are non-African-American judges who are part of the Judges Association. But I do think the onus is on this group of jurists to make a difference in how the judicial system and our justice system, the impact it has on African-American communities in Ohio. I mean, if not this group, who? And so it has met a couple times. We've had a few, it's just getting off the ground for the most part. But I am one of the many members. I'm not an officer. I'm not a founding member. So, there are other people on this call who can better address its mission. But I think it is important for the group and the organization to really have an impact on how things are done at our court levels, at our various court levels throughout the state, and to hold entities and individuals accountable.
Thank you. Judge Collier Williams, since you are a member of that group and one of the leaders, could you perhaps just add a little bit to that?
Well, I think, thank you. I think what the justice said is very true. I mean, our goal is to make a difference. We've done a lot in our first year. We've had several CLEs that were very well attended, and we're getting, we're still on the ground level, but we are working hard to make an impact, to make sure that things are fair, that things in our judiciary is what we need it to be. So it's a lot that we're doing, and it's a very, very necessary organization, and we're looking forward to doing a lot of great things. And like Justice said, if not us, then who? If not now, then when? So we are definitely working hard to be a force to be reckoned with.
Very good. Thank you. And Judge Groves, I know you're out there and you've just asked a question. And I'm wondering if you could please ask your question about precedents.
Thank you, and good afternoon. I think one of the challenges, and I'm sure the justice realizes, and I do believe in the arc changing, the moral arc changing towards this perception and ideal of what we see as justice. So I just want to ask you, Justice, how do we do that as judges when we know that the precedence is there? We see now through reform that there are challenges that the precedents just got it wrong. And so how do we change and bend in the direction where it should be? Because otherwise we could still be operating under Dred Scott.
Well, remember that, once a court decides, be it the highest court, our court, U.S. Supreme Court, and oftentimes, your court, the appellate court, the Supreme Court is a court of last resort, but in all actuality, the intermediate appellate court is a court of last resort for most people. And so I almost think it's more incumbent on things to get right then and there. But I always say to judges who write opinions, so appellate court judges, court of appeals judges, I never hesitate to say, call out the legislature, call out the lawmaking entity when it needs to happen. There are times, if you notice in our opinions, where we say, this should happen this way, but it's up to the legislature to do that. And so hopefully this will, spur on the legislature to do that. We really, I think even those of us in the know, those of us who are in the law field, I think we don't really appreciate how important it is in electing our lawmakers. And that is, to some degree, city council, but more so our state representatives and our senators and our members of Congress, because they make the laws. And remember, all of those people are not lawyers. And that oftentimes shocks people when you say, well, our lawmakers aren't all lawyers, because I think we would only want scientists and healthcare professionals like mixing our vaccines and doing our, taking care of our medical problems. But and I know there are lawyers who are in the legislature, but a lot of them are not. And so oftentimes legislation is enacted based on lobbying efforts or based on something that happens in a unique circumstance in a small county in Ohio that then affects the entire state because it applies to everyone. And so, when those things happen, I think, again, it's incumbent upon us, those of us who are lawyers, to be on these commissions and when we want to change the role of Supreme Court, we put it out for public comment on it. Read about it. Have somebody in your courts that look at these things every time. I don't know if it's a court administrator or if it's somebody in a particular department, and that question, in my opinion, is one of the things that the Ohio Black Judge Association needs to have. We need to have someone at all times looking at legislation that's about to come about, looking at court decisions that will have a major impact, maybe a disproportionate impact on communities of color or poorer communities. If the organization does nothing else but monitor those things, it will be time well spent. And I think it will make a major difference in how we do our jobs.
Okay, here's another question. Have you thought about using slip opinions more often to do error correction? The effect of no correcting leaves us in certain jurisdictions with bad law.
I'm sorry, say that again. Have we thought about doing what?
Using slip opinions more often to do error correction. The effect of no correcting leaves us in certain jurisdictions with bad law.
You're absolutely right, whoever wrote that opinion. And sometimes too, excuse me, frog in my throat. Sometimes too, though, we do see it's bad law, but the case isn't clean enough for us to decide it. Meaning there's some procedural impediment that we can't quite take it, and we have to wait for a better case. And so sometimes when that law is bad, we try not to take cases, and then once we get the record, we see how procedurally yucky the case is, and then we'll have to dismiss it as having been improvidently accepted. And we hate to do that. You hate for us to do that. You know, society hates for us to do that. But remember, when we get the jurisdictional appeals, we don't have the record. And sometimes there's so many other things that are involved in the case that adjudication of that issue just can't happen cleanly. And when that comes up, then unfortunately, yeah, we do have to leave the bad law out there. But there will be a time where it will come back again. And also, never, ever, ever hesitate for the lawyers to file an application for reconsideration. When I was on the Court of Appeals, I probably granted more of those than anybody else on the court. And I have to say, oftentimes, in my opinion, it was due to the ego of some of my colleagues. You know, nobody likes to be pointed out as being wrong. I don't have any problems with you pointing out when I'm wrong, because I'm more concerned that the case is decided correctly. And I remember during times leaving the court, I reconsidered a multi-million-dollar personal injury case that the other side pointed out a fact that I found. And so change that, and you have to decide. So you can spur on your local media to write about it, because then it stays in our screen, in our radar, in the lexicon, because we shouldn't have that law out there. But there are times when, you know, we just can't, you know, just can't take it in. We can't solve all the ills. That's part of my frustrations in the job. We can't fix everything, even though I want to.
Okay. Here's a question. So what is the judiciary, the judges organization stance regarding the current CSU Cleveland Marshall College of Law name change effort?
Does the association have a stance position on that? If so, I don't know it.
I don't know.
Yes.
Yes, we support it.
You support the name change?
We support the name change.
Want to know my personal position?
Go ahead.
It doesn't matter one way or the other to me.
That's all right.
And that's speaking from an alum of the school. And don't get me, I totally understand. I completely understand those people who advocate for the name change. I get it. If the name changes, I'm fine with that. If the name doesn't change, and as I said to Dean Fisher about it, you know, part of it makes me smirk a little, because if for all the reasons, all the legitimate reasons that people are interested in changing the school's name, I smirk at the fact that our law school is known for having so many firsts in the African-American community, starting with, you know, Carl and Lewis Stokes, and, you know, with Marcia Fudge, and with Judge Jean Merrill Capers, and, you know, Judge Lillian Burke, and, you know, just so many people that I would imagine John Marshall's rolling over in his grave, or that maybe, you know, he would have seen things differently, and or, you know, that the school takes on Thurgood Marshall's name, which I think would also be an appropriate, easy way to do it. So at the end of the day, I lose sleep over a ton of stuff, but that won't be one of them, regardless of what the decision is. And that's just my personal take.
Thank you. Here's a question. Would you like to be nominated to a federal judgeship?
Would I like to be nominated to a federal judgeship? If I am considered for a federal appointment, that would be an honor, because I'm assuming it would be in recognition of the work I've done as a jurist. And so, of course, that would be an honor. However, the realities of that, I think, is one, my age, because although I may look like I'm in my 40s, I'm not. Oh, who's laughing at that? Mute yourself. There's a lot of laughter with that one. You know, being nominated would be an honor. And if somebody's still laughing, believe it or not, if I'm honored, if I'm nominated, that would be an honor. If I'm considered, that would be an honor. And you know, I could just leave it at that. And if I remain on the Supreme Court for the rest, they'll have Supreme Court for the rest of my career, that would be an honor too.
Okay. That's,
I know people have jobs, don't you?
what do you mean?
As in, like, I don't, what time are we're supposed to be over at 2, right?
Yeah, oh no, there's some more questions.
Oh,
Yeah.
I know. Alita's like, don't think you're going anywhere.
That's right. You just,
Hey, Justice, it's Brendan Sheehan.
there you go.
What do you do to keep saying outside of court work and reading briefs? What do you do for fun?
You know what, Judge Ian? I just had delivered to my house 2 days ago. I can tell you, I've always, my primary was piano. I've been playing that for about 50 years. And I still play. And I have a piano in my living room, and a piano in my basement, I still play. But two instruments I always wanted to study, play. And I studied guitar for a while, bass guitar and drums. And so I kept waiting for the time to be right? And as we know, that really never happens. So you either do it or you don't. And so one day I was drooling over a case, and I was like, oh, I could just bang on something. And I said, you know what? I'm going to start taking drum lessons. And so last year I started taking drum lessons, and I bought a drum set. And now that's kind of what I do between walking and playing piano and banging on my drums. That's how and I feel so much better when I come back and get to the computer, especially when I've read a dissenting opinion that's has a little more, shall we say, venom in it than I think it should. And then I have to, figure out how I'm going to respond appropriately. So that's what I do.
That is so awesome. I just want to say, I want to thank Judge Albert, Judge Cassandra Collier-Williams, Justice Stewart for being here. And I just on behalf of the court, I'm proud of what Judge Cassandra Collier-Williams and our diversity committee has put together. I just want to say thank you. But I know there's other questions, but on behalf of my role as administrative judge, I want to say thank you for all that you're doing.
So thank you for doing this. And I like this panoramic view of your office. Did you clean it up beforehand, or it always looks that neat?
It's always, it's not as good as your background with the Justice Center and the federal court in the back. So I love that.
Yeah.
Here's a question for you, Judge. What do you believe is the true role of an Ohio Supreme Court justice?
To keep everybody at the court happy. A true role. I'll tell you what I think my role is. Okay. So I don't speak for my other 6 colleagues, but I think my role is to, as all my other judicial colleagues in your courts do, is to adjudicate every case that comes before me fairly and competently. The most important case I have is the case that's currently in front of me. And I know we all have multiple cases before us, but either the one you're on the bench for, listening to at the time, or the one you're writing an opinion about or a judgment about. And they are, and I don't care how mundane the issue is, they're important to those clients. As a statewide elected official, I feel I have a responsibility to be available to any individual or any entity across the state who wants or needs me for something. Obviously, there are parameters, there are restrictions to that. I can't give it legal advice, can't talk about a case, before we decide it. So with restrictions, but when I ran for the court, when I was running for the Supreme Court, there would be people who would say to me, you're going down to X county in southeastern Ohio, you're going over to Y county, that's 99.99% Republican. You're going, and I'd say, well, yes, because I'm running for the Ohio Supreme Court, not just the Northeast Ohio Supreme Court or the urban Supreme Court or the or the most populous county Supreme Court. I'm running for the Ohio Supreme Court. And so, yeah, I'm going to those places because if I don't, then the only impression those people, and you only see a small amount of people in the county, but what they will know of me is what the political party says about me, or what they may or may not read, or what they discern based on my name. And so, when I walk in a room, the first thing you see is a Black female. And so if that's the only thing you have to go on, depending on whether you have positive or negative biases about a Black female, will then inform your vote. But if I get a chance to talk to you and at least tell you why I'm running and why I think I'm a better candidate, it gives you something else to evaluate. And so, and likewise, I felt that way as a candidate, I felt that way as a statewide elected official. I'm going to go anywhere in the state where I ask about ratings and competence. So that responsibility, I feel it's a responsibility. I try to take on as many externs as I can from the law schools, not only in our state, but from outside the state, which reminds me, we've got to respond to somebody. I feel being in this position to help get lawyers in training ready as much as possible. There are probably more students of color who apply to for an externship at the Supreme Court than maybe before I was there. I know I never thought of an externship at the Supreme Court or any court when I was a law student. It just wasn't, again, on my radar. It just wasn't either because it just wasn't anything that people talk to students of color about as often, or if you're a first generation college graduate or first time in your family, you don't think about those things. And so I try to impress that upon college students and high school students, more so. And I try to make sure that everybody at the court is treated fairly and everybody feels that they have the best opportunity to do their jobs to the best of their ability. My 1/7 vote, or with my chambers. And so in the time that I'm there, whether it's just this remaining 3 years, whether it's another 1 term or 2 terms or however long it's there, I need to maximize my time at the court for others. And that's just not the administration of justice. It's a kind of a broader perspective.
Thank you. Here's one for you. How do you think the Texas abortion case will be decided?
I don't know enough about the facts or the legislation, to really comment on it. It used to be a time where we couldn't even comment on it, but we've changed the rules, judges, the Supreme Court rules, such that, judges and judicial candidates can comment on things as long as it's not something that could come before them. And seeing as that's another court and can't come before me, I might comment if I knew a little more about it, but I don't. But my sense is from what little I've read and what little I've heard, my sense is the court, don't be surprised if the court decides to kick the issue to the states, such that states can decide amongst themselves. And then of course you'll have, people, women who are seeking abortion who are in states that restrict it or don't allow it at all, going to states that do allow it. And, so I don't know. I don't know that would be the decision, and I don't know the overall impact of the decision. It's really kind of a wait and see. I try generally not to feel strongly about things over which I have no control, so I just kind of take a wait and see approach.
Judge Rose, you made a comment. Would you like to share it?
Sure. I just want to thank you, Justice Stewart, for your candor. Many judges will hide behind the shield that I'm a judge, and I cannot speak on particular issues, but I have found your comments to be very enlightening and empowering. So I thank you for the example that you have shown today.
My pleasure. Thanks for having me.
Okay, here's another question. Do you like the Ohio recusal policy? When a federal justice recuses, the Supreme Court votes without him or her. When a state justice recuses, the justice is replaced with a lower court judge. Do you think one policy is better than the other?
Oh, I never gave that much thought. I would say that the way this Ohio Supreme Court does it, and this is not necessarily a reflection on how the Chief Justice does it now, because quite frankly, I don't know. But if I were Chief Justice, I would have a list. And it's just in case all of you don't know, when one of us has to recuse from a case, then the Chief Justice appoints usually a sitting Court of Appeals judge to sit as a justice for that day. And in a rare instance, you might get she can use a retired Supreme Court justice or a retired appellate court judge, but often it's usually a sitting appellate court judge. To be honest with you, I'm not even sure how that judge is selected. I do know that she doesn't select judges, but I think I would have a process that was neutral, such that if I were Chief Justice, I would be accused of having a justice come on the case so that justice can decide the case, that judge can decide the case as a justice the way I want to see it lead, or the way I want to see it go. And and I don't know how that's done. The problem with not replacing that judge, that justice, is you have an even number. So if you don't replace even at the federal level, and I don't know how they do that, if one justice recuses, what if you get a 4-4 decision and then it stays like that and it's not decided? So there's courts and Supreme Court high numbers, so that there can always be a majority. And there have been plenty of cases in my court that come down 4-3. So I'm not sure how it would work. So I think I would always lean for having an odd number of judges, however that needs to work. And the judges or justices.
So here's another hypothetical for you. Will you accept President Biden's nomination to the Supreme Court?
Oh no, who would want to do that? If nominated, I would accept.
Thank you.
I think, really, I say that so quickly, I've never really even thought about that. But I mean, it seems like it should be a no-brainer, right? But it really, I have to tell you, it wouldn't really be that easy for me for a lot of reasons. One, I haven't finished the term that I've been elected to serve. One. And two, those federal jobs, I don't know if Judge Oliver is still on the call, but jobs for life, who wants to work the rest of their life? And so it's but it does seem like it'd be a no-brainer. I really would go ahead and say something, Judge Oliver. You're on mute, so we can't hear you.
I said nothing. I'm just listening to you, Justice.
Oh no, I thought you were smiling and your mouth was moving when I said who wants to work for life.
Oh, you don't have to.
Well, you don't have to. You don't see your status, but particularly, you get nominated for a federal court position. You want to do the job for a decent amount of time, and I think the climate has gotten a whole lot more political. Of course, President Trump put a lot of young people on the bench. The nominations were not very diverse by way of gender or ethnicity. I think President Biden is making a concerted effort to do that. I wish they had more diversity in education. Most of the people who get nominated from court are East Coast and West Coast schools. So there is a wealth of good lawyers and judges in the Midwest and in the Northwest and in the South. So I hope he continues to broaden his nominations based on other things just than ethnicity and gender. But it seems like he's trying to make a concerted effort to do that. I think that benefits our judiciary as a whole.
Here's a follow-up. Do you think that the U.S. Supreme Court should be expanded?
My initial, again, I don't know enough about the details of that, but I think to myself, I know what it's like trying to herd the cattle of 7 at the Ohio Supreme Court. I can't fathom what it's like trying to do it at 9 on the U.S. Supreme Court. So any more than that, it would seem to me that it would get unwieldy. And so what, expanded to 11 and then 13, then 15, then 17? So my initial reaction to that is, whoa, Nelly, be careful what you ask for. And if you think about it, this is my kind of elementary take on it. In a regular course of things, if things happen the way they're supposed to and people do their jobs, then we don't even have this discussion. Prime example, President Obama nominated Merrick Garland to be on the Supreme Court, but the Senate Judiciary Committee wouldn't hold a hearing. For over a year, a hearing was not held just to support that appointment. So I don't know why we as a nation were not outraged that the job wasn't done. Because of Justice Stewart, then they rushed through the Senate Judiciary Committee, and the Senate rushed through Justice Amy Coney Barrett's nomination. I think in record time, like 60 days, 45 days, 50 days. Yet you sat on President Obama's nomination for over a year. Had they done their job, then Merrick Garland would be on the Supreme Court. And then there's that balance. And so then we wouldn't have this discussion. Because I think the way that the presidential elections are done, and the cyclical basis of Republican, Democrat, the court works itself out that way. But then when you, in my mind, cheat the system and you don't do your job, and we allow our elected officials not to do their jobs, then we get the skew. And then we try to figure out how to fix the skew. Let's just hold people accountable and make them do their jobs.
So if we don't expand it, is there any other court reform that you can see would be beneficial?
I'm sure there is. I'm sure there's court reform that could happen. Remember, when you think about the qualifications for the United States Supreme Court, I think there is only an age qualification. I don't think there is an educational qualification. I don't think there's a time on the bench qualification. I think there is simply an age. You have to be a certain age to be on the United States Supreme Court. So that's interesting. Now, of course, in recent times, there have been no justices that have been appointed who have not been lawyers, but all of them haven't, even been judges. And I don't necessarily think that that's a bad thing. But should there be some reform? Probably. Will there likely be? Probably not. I think the politics of it always, whenever there's politics involved, unfortunately, I think politics most of the time prevails.
Okay.
Okay. Let me just ask a real fast one because we're almost out of time, but just curious, as a sitting Supreme Court justice, do you have a type of case that you really prefer to dig in and to decide? Criminal, juvenile, civil, or do you have no preference?
I really don't have a preference because, I guess I'm one of those people who is intellectually curious anyway. And so my erudition increases exponentially in the cases that we have, especially cases with which I have little to no familiarity, even coming from the 8th District. So for instance, in the 8th District, the 12 years I was on that bench, I never saw a single solitary case dealing with mineral rights or fracking, those sort of things. Coming out of the Valley area, Mahoning County, and some of the counties in our state, those are issues. Surface rights and subsurface rights, and mineral and oil and gas. Those things. So that's a whole area of law that I've had to learn more about. Dealing with the public utilities and the public utility commissions. So those are, and so it's interesting when there are things that I haven't had to deal with. So it's all interesting. It varies by way of and then the death penalty cases. I've never, since the legislature has taken death penalty from being directly appealed to the appellate courts, I think that happened about 25 years ago. Now we get direct appeals of death penalty cases. Now in the Court of Appeals, I think I had 1 or 2 post-conviction cases dealing with death penalties, but not directly death penalty cases. And so they're like 20, 25 assignments of error that come to us for death penalty cases. The very first case I heard as a Supreme Court justice was a death penalty case, and I was chosen to write that case. So that was that. I think the opinion was 150-page opinion dealing with 25, 26 assignments of error. And so even those, the law and that, and I have begun to, because I wasn't exposed to it as much. Now that I have written cases where I'm hoping to move the needle a little bit in that. And I will say, just be very plain and forthright about it. I'm very concerned about what we allow jurors to see in our courts, particularly when it comes to heinous criminal homicide cases. I already think we have a society that is exposed to stuff that some people don't want to see or would rather not see, but it's usually too late because social media has picked it up. But for those of your trial court judges and autopsy pictures and crime scene photos, and the prosecutors always say, well, we got to prove all the elements of a crime. We got to prove the aggravating factors. Not really, not all the time, especially when there's been a concession of how someone was killed or a concession of how someone has died. And so I think we really need to. So at least in one of the opinions, I have said, all of the stuff doesn't need to come in. One, it's cumulative, it's prejudicial, and then the prosecutor always says, yeah, but there's overwhelming evidence of guilt, so it's harmless error. Well, hopefully one day we stop saying that it's just harmless error. And we have to think about the men and women on the jury, and it might be that we just tweak how we present this to the jury. If we say to jury members, there are going to be some graphic crime scene photos or autopsy pictures, if you don't want to look at these, you don't have to. And I think we need to say that to people. I've had people come back to me to say, I will never serve on a jury again. I never want to see that kind of stuff. And if it's not salient to a determination of guilt and evidence, guilt or innocence, then we really need to protect, I think, our jurors who take the time, who have to be there by summons, who have to be there but serving their duty. They don't get paid. They aren't parties to the case. They aren't the judge or the lawyers who are getting paid to be there. I think we really need to look at ways of protecting them from some of this stuff that really, quite frankly, they don't need to see.
Wow, thank you so much. I mean, I really want to thank you for agreeing to speak to us today, because just this hour and a half, you have really encouraged me to be a better juror. A better jurist. And I think I think there's a number of judges on here today who would probably echo what I'm saying. It is, you are very encouraging, and you give us insight that sometimes we don't think about. Because we're dealing with the weeds every day. And sometimes we need to step back and say, just like you just said about everything going to the juror, do they really need to see all that stuff, and how prejudicial is it? So I really want to thank you. It is 1:58. I think, Alita, did you want to do one more thing before we got off the line?
Yes, I do. So thank you, Justice Stewart. And we just have one more thing to share with you. And if I'm going to share the screen. Can you see that?
Happy birthday.
Happy birthday.
Well, thank you. Not quite my birthday, but it is.
I think it's Saturday, right? Is it Saturday?
I don't reveal my birthday for one.
Okay. All right. All right.
I tell people it's February 30th, and then they try to put it in their calendar.
Well, I hate to say it, but it's in Wikipedia.
Yeah. Well, I have two different ages in Wikipedia.
Oh.
And I usually try to go by the younger of the two.
Well, we're wishing you happy birthday anyway. So
okay.
You're getting lots of thank yous.
It is Saturday, I think. I'm glad you reminded me, because actually I thought it was tomorrow.
Oh, for God's sakes.
I remember I'm a cuspy, not quite Pisces, not quite Aquarius.
All right. Well, thank you again. You were amazing, as we all knew that you would be. And this is our court's History Month speaking. We have a lot of other events like movies and poems and books and all that stuff. But we speak every year because we think that it's really, really beneficial to all of our the people in the court, as well as the judges all around the state. So thank you again, and everyone have a great rest of the day. Thank you. And thank you, Judge Oliver, as well for that. Thank you.
Bye-bye.
Thank you.
Bye.
Happy to be here. Bye.
Great job, LD. Bye-bye.